Welcome to the Family Law Channel here on the Legal Broadcast Network. I'm Scott Drake with my guest, the Honorable Retired Eugene M. Hyman, Superior Court Judge, Santa Clara, California. We're talking about an article in Forbes which is addressing legislation to reform alimony in many states, which looks like it's not going to help women in divorce that much. Judge Hyman, welcome back.
Thank you.
And it looks like all this reform going on really, when you look at it, it just, as the article says, it's just going to create more uncertainty for divorcing women, because it looks like in every case they're going to get less.
Absolutely. I think, as proposed, I think it's pretty dangerous.
Mm-hmm.
You know, alimony is one of those things that where you live, as I have said several times in many different contexts, justice is local in terms of how things happen, and alimony support is one of those things that's very local in terms of the community standard, in terms of how an evaluation is done, in terms of how the family was living prior to the divorce. The fact that there is a 50% division of property, which is one way of compensating in terms of unequal bargaining position, is just one of several factors that usually, not always, but usually the man is the high-income earner, and usually, although not always, the woman has been the one that has had the lower-paying job or has stayed home to take care of the children. And when you're talking about a person who is older, which is over 50, that person's going to have a hard time getting a job. So if you have a long-term marriage, which is defined in California and most states as being over 20 years, that person is at a real disadvantage in terms of getting back into the workforce. And I know that when I've been in those positions of setting in support, you look at the person's skills, because usually if there's a significant income involved with respect to one of the parties, there's been a job development report generated, and if you've got a person with minimal education, high school, maybe a couple years of college, that person is going to have difficulty getting a job more significant than working at fast foods or as a greeter at Walmart. And to require that as a result of that somehow the person's going to get less support or no support is just blatantly unfair in my view.
Yeah, and they're talking about a couple of states here, Florida and Massachusetts. There is one in Florida which terminates alimony payments when the payer reaches retirement age, and then it lists this nightmare scenario where a woman who has been married for 35 years, is age 61 or so, and gets divorced, and her husband's 62, and she gets 3 years of alimony payments. She's probably what many would consider unhirable because she hasn't been in the workforce, and that puts her at an incredible disadvantage, doesn't it?
Oh, absolutely. See, the other thing that people don't realize is that if we're talking about a person who is younger, who either has been employed, is capable of being employed, then there are ways in terms of modifying spousal support. Spousal support, like child support, is always capable of being modified unless there was a settlement that said that it wouldn't. That is, that a person would get support at a certain level for a period of 10 years or whatever. But absent that, based on a change in circumstances, and judges are usually capable in terms of orders. There's all different kinds of ways of doing it. One is a step down. That is, over a period of time, it's stipulated to by the parties that the person will receive less support over a period of time. The other is to have reviews in terms of seeing what work efforts are being made by the person who's receiving support. And a judge can, if the judge feels, based upon the evidence, that the person wasn't making a sincere enough effort, then the judge can go ahead and reduce the amount of support based upon that factor. Another factor is to have a person get another job evaluation in terms of an expert to see over a period of time whether or not the situation has changed.
Final minute here. I mean, given the current economic conditions and how hard it is for anybody with recent experience to get a job, it seems especially difficult right now for a divorced person who hasn't worked in 30 years. Talk about California, because that's where all your experience lies. Is California a good model to keep in place?
I think that it's as good as is humanly possible. Certainly not ideal, but on the other hand, long-term. Actually, in California, long-term relationship starts with 10 years. One of the things that California looks to, unless you have something significantly longer, is basically half the length of the marriage is sort of the standard that one begins with in terms of support. But again, in terms of how much that support is, you really have a community standard. Support in Santa Clara County, San Jose, is going to be different than, say, support in San Bernardino County, based upon the same kinds of evidence. There is an expectation that you're going to have a certain standard of living in one county, and an expectation will be a different standard of living in another.
All right, Judge, great pleasure talking to you once again. Thank you.
Thank you.
And you're watching the Family Law Channel here on the Legal Broadcast Network.